I hope that I will be able to share those reasons. I'm a strong believer now in the future of transnational commercial litigation. So thank you very much for this opportunity indeed. So the outline of my presentation, you will allow me first to explain a little bit what is the Hague Conference, what is the HCCH, go through its mandate, its membership, some of its core conventions and its regional presence. And I also will then in detail describe, explain the structure and how the convention works. I will do that in as much detail as possible since we have much time to discuss it. And then I will try to make the point on why is it important. I will try to answer this question very clearly from practitioners' point of view, from policymakers' point of view, and I will add a note on the relevance of international commercial courts vis-à-vis the convention. And then I will finish with a challenge, a question that hopefully, if there are students among our audience, can prompt you to do research, to publish papers in response to that challenge, which I will submit is unsurmountable. You will not meet the challenge, but I stand to be tested on that. So what is the Hague Conference? We now call it HCCH, and I will come back to the acronym in a bit. I ask you time to present on the Hague Conference because often the organization is not well known, even though it's one of the oldest legal organizations in the history of mankind. And it's actually an intergovernmental organization. So it's not an NGO, it's not a group of outstanding experts. No, it's an organization, a state-to-state organization. And its origins go back to the 1893, where the first conference took place. And it was mainly an initiative by its founding father, Tobias Asser, who, by the way, won the Nobel Prize later on, precisely because of setting up the Hague Conference. And we are proud of that, of course. Later on in the 50s, so after the Second World War, the establishment of the UN, a resurgence of multilateralism and setting up of new international organizations, the conference, which until then would work through several sequence of conferences where delegates would meet. In the 50s, it establishes itself as an intergovernmental organization with a permanent secretariat, which we call Permanent Bureau. And its mandate, it's very clear. The mandate is the progressive unification of the rules of private international law, a conflict of laws, put it in very simple terms. Of course, rules on jurisdiction, rules on recognition and enforcement, and applicable law. Now there's a fourth pillar developing significantly, which is the pillar of legal cooperation. We currently have, and since the 50s, we only count these conventions since the 50s, since there was the permanent secretariat, so they are older conventions, which usually we don't refer to. Many are not in force anymore. So there are currently 37 HCCH conventions, known until recently mostly as Hague conventions, and I understand that that's the way people refer to our conventions, as Hague conventions. The Secretariat, the Permanent Bureau, is making an effort to rebrand the conventions as HCCH conventions, and these conventions fall under these three fields of law: family and child protection, legal cooperation, and transnational litigation, which is the package of conventions for which I'm responsible and primarily responsible at the PB, the Permanent Bureau, and then commercial and financial law. To give you a sense of how the organization is spread around the world, you can see here in blue those that are the members of the organization. And we have currently 85 states as members of the organization. And then we have the European Union as a member in its own right. And then we also refer often to the connected states, connected parties, 69 more in addition to the 86. It's not polite to refer to them as free riders, but let's say that these states were not involved in the negotiation as members of these treaties, but they can join because in most cases the conventions are open for any state to accede to them, and therefore there are 69 states that have joined our conventions, even if they are not members of the organization, and therefore do not participate in the legislative process and also in the process of reviewing their operation. Just a quick note regarding China. So China is a member since 1987. It has joined 3 conventions, only 3 out of the 39. Basically the Service Convention, which is the 1965 Convention on the Service Abroad of Judicial and Extrajudicial Documents. Also the 1970 Convention of Taking of Evidence Abroad, and the 1993 Convention on Protection of Children and Cooperation in respect to inter-country adoption. Those 3 conventions are in force in mainland China. Just a note that, of course, some conventions had been extended by the United Kingdom to Hong Kong and by Portugal to Macau, and therefore they are applying in Hong Kong, and in that case many more. So there's a 1961 Convention on the Conflict of Laws relating to the form of testamentary dispositions. There's also the apostille, also the Service Convention, the Recognition of Divorces, the Evidence Convention, the Child Abduction Convention, and also the Trusts Convention, all apply in Hong Kong. This is the core conventions divided by its 3 main areas of our mandate. So you can see on the left side our most well-known conventions: the child abduction, child protection, child support, and then the package of legal cooperation and transnational litigation that goes from the apostille, which we consider a legal cooperation convention, and then this package of conventions that actually supports transnational civil litigation, commercial litigation, the service of process, the taking of evidence, the choice of court, and judgments, which is our latest convention, which I will refer to briefly. And then we have a package of 3 instruments on trusts and securities, and also some principles on choice of law in international commercial contracts, for which I'm also responsible. This is the trend lines of adoption of our conventions. And so sometimes I'm asked, what is the future of our conventions? If we look at the trend lines, they are clear. They are always going up at different paces. I would submit that our conventions require a certain level of institutional engagement and development. Sometimes we require competent authorities to be designated central authorities, and also requires a certain level of development of the judiciaries and engagement of the judiciaries. And so it is not out of this world to submit that our conventions trend lines follow a little bit the institutional and judicial development around the world. And the more this is developed, the more our conventions have the right conditions to prosper. Regional presence, I am not checking the list of participants now, but I'm hoping also that my colleague, Professor Yun Zhao, would be here. He is our representative for Asia and the Pacific. He is our man in the region. We have an office since 2012 that represents the Permanent Bureau and promotes and assists governments in the region to join our conventions, and also assists directly with what we call post-convention assistance, which basically assists them in implementing our conventions. We also have an older office based in Buenos Aires since 2005, which covers the entire Latin America region and also the Caribbean. This is an important part of our work. In many cases, states do need assistance in implementing these conventions. So why HCCH and why the rebranding of our conventions? Well, we have 2 official languages. We don't have 6 like the UN, and it's English and French for a number of reasons, also financial, historical, and currently maybe more financial reasons. And so the acronym is just the initials of Hague Conference in English and in French, Hague Conference and Conférence de la Haye. And we believe that naming our conventions, at least it's short naming of our conventions with HCCH is more appropriate to address any confusion that we might have with other Hague conventions, with other Hague institutions. We are not a court with other courts in The Hague. And so to reduce as much as possible any confusion, we are now asking academics, researchers, policymakers to refer to us as HCCH as much as possible. So please, when asking your questions, let's try not to call it Hague Convention, but let's call it HCCH Convention. And now the reason why we are here, the convention of 30 of June 2005 on choice of court agreements. I do want to give a little bit of historical background because it is important to understand why the convention came to fruition, and also why, how it relates to other projects. How it relates to the broader considerations of transnational litigation, civil procedure, global standards on civil procedure. And so by understanding its history, maybe we also understand why it is not a perfect convention. And by the way, there is no such thing as perfect conventions. They are indeed the result of very significant and complex negotiation processes. And so the reason I'm highlighting these different stages is because we are talking about a very intense intergovernmental process with delegates from member states, sometimes diplomats, sometimes experts, sometimes both. And throughout these different moments, there was the need for state consent, for mandates for this negotiation. And adding to all of this, the way we make decisions at the Hague Conference is by consensus. And things need to be agreed upon by consensus. At the very beginning of this project, it was not really by consensus, but then with time, indeed, the decision-making process is by consensus. And that introduces a different set of rules and values to be put forward in reaching agreement in these very complex texts that are in one way or another very much related to sovereignty issues, of course. So the Choice of Court Convention is part of what we call the Judgments Project. And the Judgments Project started in the early 90s, so a long time ago. And it was basically a proposal by the United States of America that wrote a letter. The then legal advisor of the US Department of State, Edwin Williamson, in 1992 wrote a letter to the Secretary General of the Hague Conference, George Draws, and the proposal was to develop a very comprehensive instrument on jurisdiction and recognition and enforcement of foreign judgments. So both components, but at the time, the proposal then evolved or tried to be based in a very specific proposal by Arthur von Meeren with a very original and even brilliant proposal, the mixed convention proposal, which basically would specify authorized grounds of jurisdiction, prohibited ones, and then those that would not follow in these two would be left as a matter for national law to decide. However, by 2001, it was clear that it was over ambitious, and therefore the project was scaled down, and they started to focus at that time, the negotiators, on creating separate instruments for jurisdiction and for recognition and enforcement, starting with recognition and enforcement. In any case, it was felt that there was room to focus on issues of jurisdiction based on choice of court agreements. So an informal working group was set up within the Judgments Project, focusing on this, on choice of court agreements in business-to-business cases, and also on, so just to say that this group was chaired by Professor Alan Philip from Denmark, but it included participants from the European Commission, from Germany, from Spain, from the UK, from Argentina, Brazil, China, Egypt, Japan, Mexico, New Zealand, the Russian Federation, South Africa, and the US. I'm just underlining this because sometimes I read some views that this was mainly a European project, and that is really not based on facts, because the negotiation was really owned by countries from all sorts of legal systems. So it was highly participated and engaged by different jurisdictions. So this effort of this working group resulted in what we know now is the Choice of Court Convention. It was adopted in 2005, as Alan well noted, but it only entered into force just 6 years ago, in 2015. And this convention, of course, as we will see, combines rules of direct jurisdiction with rules of recognition and enforcement. The main policy driving force for the convention was, of course, to promote and recognize and support party autonomy, which in this field is a major breakthrough from a policy point of view. The choice of court is not a mixed convention, so it's a double convention because it deals, of course, with both questions of jurisdiction and recognition and enforcement. Then after the convention was adopted, work continued on a simple convention dealing only with recognition and enforcement of foreign judgments, and therefore not concerned with matters of direct jurisdiction, and I will come to that later. In other words, this work that continued after the Choice of Court Convention does not respond, the Judgments Convention does not respond to the question as to when courts have jurisdiction in proceedings instituting for the first time. It only includes rules on indirect jurisdiction. A little bit of purpose, why this convention was approved. It was not for minor reasons. Let's say it was not to replace arbitration in any way. It's actually to fill a gap. And so the convention fills a governance gap, if you wish, that existed in the absence of a uniform global legal regime concerning the effect of choice of court agreements. And so from that perspective, it is a major milestone in international civil procedure because it enhances free movement of goods, services, capital, and persons, like we always say, as arbitration does, but also a freer movement of judgments. And that provides also an opportunity to create a worldwide judicial alternative or complementing alternative to business dispute resolutions. And like the New York Convention, this convention, we believe, is on track to become a global instrument, and I will explain why later on. It is suitable for ratification by all states and ensures this respect for party autonomy by giving effect to forum selection agreements, and also efficiency by permitting a relatively easy recognition and enforcement of foreign judgments. So its purpose, to sum up, is to encourage cross-border trade and investment by enhancing international judicial cooperation through uniform rules on jurisdiction and on recognition of foreign judgments in civil or commercial matters. So by itself, it doesn't bring anything negative to the world. So it complements this idea of transnational dispute resolution system, and it provides one more set of predictable rules that states consent to, and that's very important to underline. Just some fun facts, or maybe not, actually facts. So currently 32 HCCH members are bound by the convention, but it's important also to note that at this stage 8.4% of the global citizenship or of businesses around the world have access to the convention, or let's say businesses representing 22% of the global GDP have now access to the convention. So even if the number of 32 might pale in relation to other older, much older conventions, we cannot ignore that the number of states represents a certain number of citizens, businesses, and GDP. So a convention that is accessible to 22% of the global GDP is indeed already a relevant convention just within 6 years of its entry into force. So the first state to ratify the Choice of Court Convention was Mexico in 2007, and then it was followed, of course, by the European Union in 2015, and as such it entered into force. And it then has been ratified by Singapore in 2016, and then Montenegro in 2018. The convention entered into force in October 1st, 2015. And at that time, so enters into force for the whole European Union, its 28 member states, including Denmark, which acceded separately, and then Montenegro and Singapore, as I mentioned. So in addition to the ratifications, there is also several states that signed the convention, and we all know what signing the convention means is that those states in principle should not act in ways that are contrary to the purpose of the convention. So that's already very significant, especially because the signatories are the US in 2009, Ukraine in 2016, China in 2017, so only 4 years ago, and North Macedonia in 2019. Just as, and I know there's a tendency to compare this convention with the New York Convention, even though it's not really a fair comparison, but let's say that for the purpose of analyzing this with a little bit more data, it's important to remember that, for instance, it took the New York Convention around 10 years to have the same number of parties. And it took 12 years for the USA to join it, and almost 30 years for China to become a party. I do believe that, as I said, this convention is deeply linked to also the development of the judiciary around the world, and it's not difficult to recognize that over the past 30 years, judiciaries around the world have developed, have expanded, their training capabilities have expanded, their language capacity of the judges has expanded, and so the complexity of the judiciary around the world has increased. And I think we cannot analyze the progress and development of these litigation conventions without analyzing the development of judiciaries around the world. It's not by chance that many programs, bilateral and also UN programs on rule of law development, judicial development, are aimed at supporting the development of judiciaries around the world. So this is a fact that cannot be ignored when analyzing this particular convention. Arbitration is a totally different ballgame, actually linked in a certain way to the lack of development of many judiciaries in the 60s, 70s, and 80s. But I will come back to this a little bit later. Brexit, I have a slide for Brexit because I've read so many articles about it, and there's still a little bit of confusion sometimes. And it's important to clarify that after the conclusion of the transition period following the withdrawal of the UK from the EU, the UK continues to be bound by the convention. And so the UK has been bound by the convention since the 1st of October 2015. And in September, to ensure clarity and continuity, and by the way, that's the express will of both parties, the EU and the UK, the state was very clear that it wants to ensure continuity in the application of the convention. And so it felt that it was important to accede separately, and it deposited an instrument of accession of the choice of court convention that took effect on the 1st of January of 2021. Just to be clear in relation to future relations, so relations between the UK and EU member states, the proceedings that were instituted before the 1st of January of this year, it will be the Brussels regime applying. Proceedings that were instituted after the 1st of January of 2021, it will be the choice of court convention to apply. In relation, in what concerns the relation between UK and third states, the choice of court convention continues to apply to agreements that were made after the 1st of October of 2015. This seems straightforward, and so I hope this is helpful in any way. Let's try to dig in a little bit more in the convention. So the scope of the convention, there are three limitations, let's say, probably not the best English word, but three main features of the scope. The scope of the scope of the convention under Article 1 is that it's limited in three ways. It applies only to in international cases, it applies only to exclusive choice of court agreements, and it applies only in civil or commercial matters. Let's start with the first one. So Article 1 of the Convention defines the international, and it provides separate definitions for purposes of the rules of jurisdiction and for the purposes of recognition and enforcement. So first, Article 1.2 provides that for jurisdictional purposes, a case is international unless the parties are resident in the same contracting state and all relevant elements other than the location of the chosen court are connected only with that state. And thus, unless all elements of a case are connected only with a single state, the case is international. And the fact that the parties have selected a foreign court as the forum will not make a case international. To put this in a more affirmative way than the drafting of the convention, any case with elements that are connected to more than a single state will be international, except where the sole foreign element is the choice of a foreign forum. I must add that Article 19 permits contracting states to declare that its courts may refuse to determine disputes to which an exclusive choice of court agreement applies if, except for the location of the chosen court, there is no connection between the state and the parties of the disputes. I would say that in relation to the declarations of Article 19, if a state has an international commercial court, for instance, or wishes to encourage international commercial disputes to be litigated in their courts, it would in principle not make an Article 19 declaration. In relation to the definition of international case in relation to recognition and enforcement, under Article 1, Paragraph 3, the fact that a judgment is rendered by a foreign court makes the case international. And in this case also, Article 20 permits a contracting state to make a declaration that its courts may refuse to recognize or enforce a judgments given by a court of another contracting states if the parties were resident in the requested state and the relationship of the parties and all other elements relevant to the dispute other than the location of the chosen court were connected only with the requested state. So the convention provides very clear, well-defined limits to what is to be considered international. The second limitation is that it applies only to exclusive choice of court agreements. So it limits to the convention to those forum selection agreements that designate for purposes of deciding disputes which have arisen or may arise in connection with a particular legal relationship. And therefore, it does not include choice of court provisions selecting the courts of nations that are not contracting states. The reasoning for this, of course, was that this would encourage more states to join the convention. Article 3 also prescribes, let's say, a presumption, a formality, and also a severability rule. The presumption is that it provides that the choice of court agreement excludes the jurisdiction of all courts other than the chosen court, unless the parties agree otherwise. And the formality is that a choice of court agreement must be concluded or documented either in writing or by any other means of communication which renders information accessible to be usable for subsequent reference. This is actually a precise definition, which is a very interesting contribution to international law. It is a mandatory rule which neither contracting parties nor contracting states may modify. And then the severability rule, again, which is not an innovation, as you know, a choice of court shall be treated as an agreement independent of other terms of the contract. It limits as such the circumstances in which the existence, validity, or legality of a forum selection agreement may be challenged by requiring that such challenge be directed to the choice of court provision itself, and not only to the underlying commercial contract in which that provision is found. Again, we are all familiar with this from the arbitration regime. And then the last limitation, it only applies to civil or commercial matters. Civil or commercial matters here should and have to be interpreted in an autonomous way. It has an autonomous meaning. I would refer also to Article 23 on uniform interpretation, noting that the New York Convention does not have an identical provision, but in any case, that's another discussion. The civil or commercial matters, as anything in the Convention, should be interpreted in an autonomous way, and also with reference to its international character and in view of uniform interpretation and application. That's a very important point to understand the Convention. So it should not be read or interpreted from a domestic law perspective. So it does not entail, in this case, civil or commercial matters, does not entail a reference to national law or any other instrument. And it is primarily intended to exclude public law and criminal matters. This is a description of civil and commercial matters that is present in other HCCH instruments. And the reason is that there is substantial body of authority, including both national courts, commentary, and other materials which consider that the meaning of the term civil and commercial in other private international law contexts, it follows that commentary. And the reason, that's what I wanted to add, is that, of course, as you know, in some jurisdictions, in many jurisdictions, civil and commercial matters are regarded as separate and mutually exclusive categories. And that's why we use this expression to be more accurate. Actually, the Judgment Convention changed this, even though following the same rationale, but to be more precise, it says civil or commercial matters. So I know that sometimes this, in common law jurisdictions, this comes across a little bit as a bit strange. So Article 21, which for some is considered, problematic for those familiar with international negotiations. These valves, these escape valves, these articles are absolutely key to ensure a consensus at the international level. And it doesn't mean necessarily that they will be used in an abusive way, rather the contrary. Sometimes by being there, they are not used. In general, not in this particular case, because as you will see, there is an important declaration here. When making this declaration, the state must ensure that the declaration is no broader than necessary, and also that the specific matter that is excluded is clearly and very precisely defined. So states should not just make declarations without compelling reasons. There is the norm. To achieve these objectives, the Convention applies three principles: transparency, non-retroactivity, and reciprocity. So transparency, under Article 32, any declaration made under Article 21 must be, of course, notified to the depositary, which will inform all the other contracting parties. And even if it is made, it comes into force only after 3 months, so that allows time for all contracting parties and all interested stakeholders to be aware of it. So transparency is an important part of it. And then the non-retroactivity, since it will not apply to contracts that were concluded before the declaration takes effect. And so this is also an important part, limitation to the declaration. And reciprocity provides that where a state makes such a declaration, other states will not be required to apply the convention with regard to the matter in question. And so it creates a symmetry mechanism and should allow to reduce incentives for states to make certain declarations, because they will know that other states will also not apply the convention to the same matters. Just as a matter of an example, you can see here, and this is not exhaustive, you can go to our website. So the Hague Conference also has its website with its convention, with the status table, with all the declarations that are made. So very easy to consult. Indeed, the European Union made a declaration under Article 21, in particular for certain types of insurance contracts. The rationale here was to protect the weaker party. We anticipate, for instance, and in relation to judgments, and this is a discussion that is ongoing within the EU, this declaration will not be made because the Judgments Convention has also particular provisions in it to protect weaker parties. And so you can see there also examples of matters that are included in this declaration. So the structure of the convention, the three key obligations under the convention are very much straightforward. They are clear, simple, and predictable. The convention requires the contracting state's court to hear the disputes that are subject to a choice of court provision, designating that court as the forum for adjudication. It forbids the contracting state's courts from hearing disputes that are subject to a choice of court provision specifying the courts of another state. And then it requires the recognition and enforcement of such judgments by a court specified in a choice of court provision. So it's a very simple and straightforward a set of jurisdiction and recognition and enforcement rules. A little bit more in detail, the three obligations. And so Article 5 requires that a court designated in an exclusive choice of court agreement to hear the case when seized of a dispute, and it cannot refuse to hear that dispute on the ground that a court of another state is more appropriate, so foreign non-convenience, or that such a court was seized first, the least pendens doctrine. So the main exception here in Article 5 is that the chosen court need not to hear the case where the choice of court agreement is null and void under its law, including its choice of law rules, and that's the exception. So the convention prohibits very clearly the chosen court from declining jurisdiction. If you go to the text, it's very clear, shall not decline to exercise jurisdiction on the ground that the dispute should be decided in a court of another state. So it clearly is intended to prohibit application of either of the two doctrines, least pendens or foreign non-convenience, which are always at play in any negotiation regarding jurisdiction. The current jurisdiction project that I will briefly mention is now, of course, looking again into the two doctrines. So the null and void exception, just a quick note, was drawn from the New York Convention and applies only to substantive, not formal, grounds of invalidity. So the provision is intended to refer primarily to generally recognized grounds like fraud, mistake, misrepresentation, duress, and lack of capacity. So there is some mirroring here from the New York Convention. The second obligation is that other courts are not permitted to hear the case. Article 6 provides that a court in a contracting state other than that of the chosen court must suspend or dismiss proceedings to which an exclusive choice of court agreement applies in favor of the chosen court. There are some exceptions, 5 exceptions actually, in Article 6. For instance, the first one in paragraph A is parallel to the exception to Article 5, namely that the choice of court agreement is null and void under the law of the chosen court. And of the other 4 exceptions to Article 6, the most important is probably that in paragraph C, which applies where giving effect to the agreement would lead to a manifest injustice or would be manifestly contrary to the public policy of the state of the court sees. So again, nothing particularly new when we compare with the New York Convention regime. I would say that the convention, in that sense, the interpretation of public policy, application of public policy, of course, we don't have enough cases yet to establish what would be considered an autonomous interpretation on public policy in relation to the convention, but there is enough decisions out there to interpret public policy vis-a-vis international character. So that should not also be a source of concern, which sometimes I read, because there is enough out there about public policy that would not hinder the same standard, the same threshold to be applied to the convention as it is in the case of arbitration. The third obligation is, of course, it's actually Article 8, which parallels Articles 3 and 5 of the New York Convention. Article 8.1 ensures, therefore, that the resulting judgments from a choice of court agreement are recognized and enforced in as many other states as possible. There is indeed, again, an exclusive list of 7 exceptions set out in Article 9. Some mirror those in Article 6, for example, again, the null and void exception. In basic terms, where one of the 7 exceptions applies, the convention does not require recognition and enforcement of the judgment, but does not preclude such recognition if the requested court chooses to do so under domestic law. Conversely, of course, unless one of the Article 9's exception applies, a judgment based upon an international choice of court agreement must be recognized and enforced. There are some other exceptions concerning, for instance, the service of the document, which instituted the proceedings, or an equivalent document, and fraud in connection with a matter of procedure. The explanatory report also goes as far as to cite examples of situations where fraud in connection with the procedural matters can take place. For instance, an example would be the plaintiff deliberately serves the writ or causes it to be served on the wrong address, or where the plaintiff deliberately gives the defendant wrong information to the time and place of the hearing, or where either party seeks to corrupt a judge, juror, or witness, or deliberately conceals key evidence. So this should be also straightforward to interpret it to the extent possible. Again, public policy exception, like the New York Convention, Article 9E includes the exception. Unlike the New York Convention, by the way, Article 9E includes explicitly violations of procedural fairness or due process within the concept of public policy. I'm not saying that that is not included when interpreting the exception within the New York Convention, just noting that the choice of court convention is more explicit on that regard. So it treats procedural unfairness as a subcategory of the public policy of the requested state, and prescribing fairly elevated standard of proof that recognition of a judgment be manifestly incompatible with the state's public policy, and requiring that the specific proceedings leading to the judgment have been incompatible with fundamental principles of procedural fairness. And of course, in Article 9E, the Convention appropriately seeks to restrain, as I mentioned before, excessively broad applications of the public policy exception. Let's be a little bit more practical on how this all operates. Judge, when dealing with the Convention, again, is there an exclusive jurisdiction clause? If not, doesn't apply. If yes, is it an international case going through the criteria that I just shared? Is there any Article 19 declaration? If not, is it a civil or commercial matter? Checking also the exclusions of the convention. If yes, it is applicable. So these three steps should allow judges in, I believe, all judiciaries to clearly and safely apply the convention. Remembering that Article 19 is the one that permits contracting states to declare that its courts may refuse to determine disputes to which an exclusive court of agreement applies if, except the location of the chosen court, there is no connection between the state and the parties of the dispute. And Article 21, where a state has a strong interest in not applying this convention to a specific matter. Those are the two declaration exceptions. There is a case, there might be more, but this is the one that we have on record so far. It's important, of course, to understand, you know this very well, the cycle of a contract, the life cycle of a dispute. And so the convention is in force only for 6 years. So there might be many clauses that are still to be activated. Hopefully not. We are not here to promote disputes. But there is a case in Singapore that there was a choice of court agreement designating English jurisdiction. The party brings proceedings in the UK High Court. A judgment was given, and then the proceedings were brought to Singapore for recognition and enforcement, and it was granted in Singapore. You can easily have access to the case, of course, but the High Court did all the tests that issued the judgment, of course, and I wanted just to share with you the agreement, the clause, and as you can see there, Hermason and Co. and the client irrevocably submit to the exclusive jurisdiction of the English courts to settle any disputes in connection with any matter arising out of the engagement letter and or these terms of engagement. We don't have model clauses on this. This is something probably that we can discuss in the future. But again, an exclusive choice of court agreement should be in principle fairly easy to interpret. And so some aspects the defendant was that the judge went through, so the defendant was notified and it was a judgment on the merits of the case. And also the judge, the Singaporean judge, acknowledged that a complete and certified copy of the judgment was provided and a certificate of enforcement. So the judge went through all the different aspects of the convention and without much problem has recognized it. A little bit of the relationship between the choice of court convention, the judgments convention, and the jurisdiction project. So it's important to acknowledge that there is a new kid in the block, the judgments convention, and the judgments convention is hailed not only by the Permanent Bureau, but by many as a game changer, because it really fills another piece of the puzzle of dispute resolution. And when talking about choice of court, now it's important to talk about both conventions. They both fill that gap. The purposes are fairly obvious and the same as the choice of court convention. The convention might be in force. Again, this is a dangerous game, what I'm about to do, but we are very confident that the convention might be in force in 2022, next year. So Uruguay signed, Ukraine signed. We know Uruguay is proceeding with the ratification process, but also very importantly, the EU has started its lengthy and very detailed process of joining a convention with public consultations, impact assessments being done. They are being done, and there are good reasons to believe that the Commission will submit a proposal to Council within this year, and therefore we can hope for the EU to join the Judgments Convention fairly soon. And again, the moment that happens, it is an important moment for transnational litigation. Just some notes comparing both conventions. They have the same goals. Of course, in the case of choice of court convention, one of the main goals is the respect of party autonomy. Judgments is a broader goal in terms of circulation of judgments in civil or commercial matters, but it also applies, by the way, to non-exclusive choice of court agreements and other matters. So it complements the choice of court, and that's why I would underline this is very important. Both conventions need to go side by side. One complements the other. Together, more than choice of court, we say that together they might fill a gap in complementing the dispute resolution system. The next steps, just for your information, there is work going on, the so-called jurisdiction project, and currently there is an experts group established that met already 2 times this year, last year. It will meet again in a couple of weeks, and this experts group is assessing the feasibility, the desirability, and the necessity of developing a new instrument and basically answering these 2 questions: on which grounds can a state exercise direct jurisdiction in civil or commercial matters, and then how can harmonized rules in this area reduce the risk of parallel litigation in multiple states. So we hope that this work will continue. There is good reasons to believe that an instrument might come in addressing issues of parallel proceedings. That will be another gap to be filled in the international system of dispute resolution. So going a little bit more to the policy side, why is the convention important, and why does it complement? What gaps is it? What is addressing? So for a practitioner's point of view, basically practitioners, I don't think, can ignore it, especially in relation to the jurisdictions that are party to it. They have, of course, to know where a judgment can circulate and obtain meaningful relief. They also have to consider what is more cost effective. They also have to consider the level of predictability of the dispute, of certainty. And so for certain types of disputes, depending on its value, as many people tend to say that this is to compete with arbitration, I submit that this is a very wrong claim. The issue is not to use litigation and the choice of court convention to replace arbitration. The issue is that there are many potential disputes that don't see the light of the day because arbitration is either too complex, too inaccessible, or too costly for that particular dispute. And so this convention enables certain disputes to see the light of the day in the sense that it provides access to justice. And so when parties have to assess risks and they have to incorporate the risk of a potential dispute in the prices of the contract. If they know that there is an accessible way to solve even minor disputes, cross-border minor disputes, that reduces the risk of contracting, and therefore there's less incorporation of that risk in the dealings, and there's a sense of access to justice. And so that's how we see it, and that's how I hope the convention will proceed and develop. For policymakers, sometimes there are concerns because there are issues of jurisdiction. There's also the level of respect, probably is not the best word, but the level of support to the principle of party autonomy. So it's a process. But in the end, the convention also provides lots of flexibility. It has declarations, mechanisms that allow policymakers also to consider joining the convention with some caveats. And so the question is not to join the convention. The question is why would the state prefer the current regime of uncertainty and lack of an international standard, with all the resulting growing interpretation, doctrine going on, and case law, hopefully, that provides more predictability and enhances and enriches the transnational legal order. Why would that not be preferable to a vacuum of international norms in this field? I would also want to say that there are indeed, and I know that the arbitration community sometimes uses arguments in relation to the fact that the judiciaries across the world face issues of independence and sometimes perceived corruption. And so there's a number of risks sometimes perceived and are recognized by important organizations like the World Economic Forum or Transparency International. And so I realize that, but I would submit that by having states joining the convention and joining this international standard, by having the duty of uniform and autonomous interpretation of the convention, by putting judiciaries contacting each other and bringing them to an international realm of an international conversation that has side effects of developing the judiciaries, developing judicial training, developing legal education, and all that contributes for this idea of justice as a public good at the international level. And in a sense, it will promote some mutual reinforcement of procedural fairness, instead of just, okay, there's a side world of arbitration that is outside this world. No, I think by providing these international standards, which come with an international dialogue, these conventions and their operation are supported by a system of special commissions, which is a very important characteristic of the Hague Conference. These special commissions meet every 5-6 years to review the operation of the convention and bring together the representatives of the states, but also the judiciaries involved in the operation of these conventions. And there's this international dialogue. And I do believe that this international normative pressure would not be the word, but benchmark, has side effects in the developing of better judiciaries across the world. So there is also a very important contribution to the development of access to justice and rule of law by promoting these conventions across the world. And by the way, I think this is becoming an urgent matter for that matter. A final point is the international commercial courts. Often I've read articles critical of the choice of court convention that simply ignore the reality of international commercial courts, and I don't think that's reasonable. In a sense, International commercial courts are, of course, very beneficial for litigants. They support the principles of party autonomy. They are specialized. So one of the arguments that sometimes courts do not have the same level of specialization and know-how in relation to arbitral tribunals. It's a fact, but there's a trend now within international commercial courts where we can find judges highly specialized in commercial disputes, and also allows at the same time for very predictable and fair procedural rules and practice. Also, many of these courts now are allowing proceedings to be conducted in English, and they are, in many cases, also they provide the neutrality that arbitration provides by being a third state in relation to the states related to the dispute. And so both the Choice of Court Convention and the Judgments Convention increase the chance of success of these courts. They are the legal infrastructure for these courts to be enabled to see more cases and to see the recognition and enforcement of their judgments recognized across the world. And so these are, of course, I know there are many bilateral agreements. Sometimes there are memorandums of understanding between courts, which in civil law jurisdictions is a little bit more problematic. But indeed, these two conventions provide the legal framework for a full-blown operation of international commercial courts. And there are many. They are growing, by the way. You can see in Europe a fast-moving trend, some even because of Brexit. I would not say which ones. But you see more and more current courts coming up, and then most of the other ones are in Asia, and you know them better than I do, of course. Just to note that the ones in blue are the ones where the convention, the Choice of Court Convention, is in force, and so it is already significant in many ways. Hopefully China, which has signed the convention, will join the convention, and that will give a second life, of course, to the convention. Just to make the point, presenting a little bit more evidence, the London commercial courts, you are very familiar with them. This slide should not be used for a presentation in Hong Kong, of course, and for practitioners in Hong Kong. But again, there is a growing trend, and the London commercial courts have litigation from 72 countries, over 800 litigants, 200 cases heard. So there is a growing trend. You also see the number of litigants and the provenance of litigants being more and more diversified. And so if you package all of this with both judgments and the Choice of Court Convention, there is a growing development of a transnational commercial litigation system that cannot be ignored. And that's it. I'm looking forward for your questions, but I have a challenge and a question, because I've asked this before, but this should be, I would say, mostly like a research question for students. Can you name one fundamental reason for a state not to join the convention? And I'm sure there are some out there. I was not fortunate enough yet to be confronted with one fundamental reason, either from a technical point of view or a policy, from an international policy point of view, that would justify it, or at least reasons that are linked to common goods, goods at the international level. So I'm hoping that you give me those reasons, so that for the next presentation I can include very strong arguments against it. Thank you very much for your attention. I will be happy to answer any questions. I'll also share my email if you want to continue this discussion, including research on the convention. And please go to our website, where you have a specialized section on this convention with bibliography and also case law, and also the proceedings in relation to the approval of the convention. Thank you very much, Alan.